Which ECJ case established the right to be forgotten under EU data protection law, providing individuals with the right to request search engines to remove links with personal information about them under certain conditions? Ec Digital Rights Ireland Lated 2014. B. Google Spain SL Google Inc. v. Agencia Española de Protección de Datos, Mario Costeja González 2014. C. Schrems v. Data Protection Commissioner 2015. D. Telet Sverige ABV Post och Telestyrelsen 2016. Correct answer B. Explanation: the Google Spain SL Google Inc. v. Agencia Española de Protección de Datos, Mario Costeja González Casi in 2014, established the right to be forgotten within EU data protection law. This landmark ruling allowed individuals to request search engines like Google to remove links containing personal information that is inaccurate, inadequate, irrelevant, or excessive for the purposes of the processing. The case significantly impacted how search engines handle personal data within the EU, balancing the public's right to information against individuals' privacy rights. In which case did the ECJ rule that legislation permitting public authorities general access to the content of electronic communications violates the fundamental rights of respect for private life and protection of personal data? A. Schrems v. Data Protection Commissioner 2015. B. Digital Rights Ireland Looted 2014. C. La Quadrature du Net and others 2020. D. Maximilian Schrems v. Facebook Ireland Limited 2020. Correct answer B. Explanation: in the Digital Rights Ireland Looted case 2014, the ECJ ruled that EU legislation that allowed public authorities generalized access to the content of electronic communications constituted a serious interference with the fundamental rights of respect for private life and the protection of personal data. The court found that such widespread access violated the principle of proportionality and failed to provide sufficient safeguards for individuals, leading to the invalidation of the Data Retention Directive, Directive 2006/24/EC, which had required telecommunications operators to retain certain data. Which ECJ case clarified the criteria under which a US-based company, Facebook, could be considered subject to EU data protection law for processing data collected from EU residents in the context of its European subsidiaries' activities. A. Google Spain and Google, 2014. B. Wirtschaftsakademie, Schleswig-Holstein, 2018. C. Facebook, Ireland Lieutenant, Maximilian Schrems, 2020. D. Weltimo SRO, v. Nemzeti Adatvedelmi s Információszabadság Hatóság 2015. Correct answer D. Explanation: the Weltimo SRO v. Nemzeti Adatvedelmi s Információszabadság Hatóság case 2015 clarified the applicability of EU data protection law to companies based outside the EU but engaged in activities such as the processing of data collected from EU residents in the context of an establishment within the EU. While this case specifically addressed a real estate company, its principles are broadly applicable, including to situations involving social media companies like Facebook. The ruling highlighted that data processing activities tied to the activities of an EU establishment bring the entity within the scope of EU data protection law, regardless of where the processing takes place. What was the significant outcome of the Schrems II case? Data Protection Commissioner v. Facebook Ireland Limited and Maximilian Schrems, concerning international data transfers between the EU and the US. A. It upheld the validity of the Privacy Shield framework as a mechanism for data transfers. B. It established the General Data Protection Regulation, GDPR, as the sole legal basis for international data transfers. C. It invalidated the EU-US Privacy Shield framework due to concerns over US surveillance laws not ensuring equivalent protection. D. It confirmed that standard contractual clauses, SCCs, are universally valid for international data transfers without requiring additional safeguards. Correct answer C. Explanation: the Schrems II case 2020 resulted in the invalidation of the EU-US Privacy Shield framework, a mechanism that had been used for transferring personal data from the EU to the US. The ECJ found that US surveillance laws did not provide the necessary level of protection for the personal data of EU citizens, equivalent to that required under EU law, particularly the GDPR. While the court did not invalidate the use of standard contractual clauses, SCCs, for such transfers, It emphasized the need for data exporters and importers to assess whether SCCs provide adequate protection in practice, considering the legal regime of the third country. In the context of the GDPR, which ECJ case clarified the extent of joint responsibility of Facebook and a fan page administrator for processing personal data, highlighting the broader implications for operators of social media pages, A. Google Spain and Google, 2014, B. Wirtschaftsakademie Schleswig-Holstein, 2018, C. Schrems V. Data Protection Commissioner, 2015, D. Fashion ID GmbH & Co., KGV Verbraucherzentrale, NRWEV, 2019. Correct answer, B. Explanation: the Wirtschaftsakademie Schleswig-Holstein case, 2018, clarified the concept of joint responsibility under the GDPR. It held that the administrator of a Facebook fan page and Facebook itself are jointly responsible for the processing of personal data of the page's visitors. This landmark ruling highlighted that entities which determine the purposes and means of data processing, even if only in part, can be considered joint controllers and thus share legal responsibility for complying with data protection obligations. This has broader implications for all operators of social media pages and potentially other online platforms where third parties can influence data processing activities, which ECJ judgment addressed the conditions under which national authorities could access retained data, establishing the necessity of limiting access to serious criminal offences and requiring prior review by a court or independent administrative authority. A. Tele2 Sverige ABV Post och Telestrelsen and Secretary of State for the Home Department, V. Tom Watson and others, 2016. B. Digital Rights Ireland, Lutid, 2014. C. La Quadrature du Net and others, 2020. D. Schrems, Vive Data Protection Commissioner, 2015. Correct answer, A. Explanation: the joint cases of Tele2 Sverige ABV Post och Telestrelsen and Secretary of State for the Home Department, V. Tom Watson and others, 2016, significantly contributed to the jurisprudence on data retention within the EU. The ECJ ruled that general and indiscriminate retention of traffic and location data is incompatible with the Charter of Fundamental Rights of the European Union, except for the purpose of fighting serious crime. Furthermore, access by national authorities to retained data must be subject to prior review by a court or an independent administrative authority, and the affected persons must be notified once such access would not jeopardize investigations. This set of criteria ensures a balance between privacy rights and security concerns,